The allegations are horrific, and out of respect for the juvenile victim and her family, I'm not going to go into many of the horrific and violent details of the crime that was perpetrated against this innocent child, but her father is now facing charges, including abduction and murder in connection with this brutal and senseless crime. But today is about systems. It's about the process that's in place here in the state of Ohio. And it's about whether or not Ohio's child protection structures give us every possible chance to intervene before tragedy strikes in our community. In the time leading up to Kei'Mani's death, there were 3 separate contacts with Children's Services, 2 abuse investigations, and 1 kinship permanency review. Those cases were investigated. The child was interviewed separately. Informal safety and family assessments were conducted, and allegations were even denied, and those cases were substantially found to be unsubstantiated. And later, state review found that the required interviews were completed, the risk and safety assessments were performed, only 1 compliance issue was identified, a delayed documentation entered into our SACWISE, the statewide automated child welfare information system, and it was found that that delay was deemed not to have impact on the actual investigation. That means by the letter of the law and the procedures in the state of Ohio, they were followed, and yet the procedures failed Kei'Mani that day. When tragedies occur despite procedural compliance, that tells us something very important. It tells us that we must evaluate not only whether boxes are checked, but whether our systems communicate effectively, they share information in real time, and elevate concerns before they become fatal. In Kei'Mani's case, teachers reported visible injuries before her death. Community members later said the situation felt preventable. Whether that is ultimately true or not, the fact is that so many felt unheard in this situation, telling us that trust was broken in our system. And that is why we are introducing Kei'Mani's law today. This legislation makes several important improvements to Ohio's child protection framework. First, it requires every public school in the state of Ohio to designate a child protection liaison. This individual will serve as a trained point person responsible for managing cases involving suspected abuse or neglect. Teachers should not feel like they submit a report into a void. Schools must have a clear and accountable connection to the child welfare system in the state of Ohio. Secondly, the bill strengthens and modernizes Ohio's uniform statewide automated child welfare information system, known as SACWISE. Reports of abuse or neglect must be entered immediately with no delay. The system will generate automatic notifications to the appropriate entities when a report is filed, and it will require biweekly updates to ensure cases remain active and visible until defined closure conditions are met. The legislation expands authorized access for statutorily defined purposes to include our juvenile courts, our law enforcement agencies, and child protection liaisons. It also permits our public children's services agencies, upon request, to provide information to our criminal courts, which is currently a gap in the system. This bill maintains full compliance with all state and federal privacy and security standards. In addition, the Department of Children and Youth will be required to provide mandatory training on our SACWISE access and use to all individuals and entities with system access. Child protection liaisons will receive a comprehensive overview of Ohio's child protection process. The department will also submit quarterly compliance reports to the General Assembly to ensure accountability and transparency. And while this legislation is not about blaming a single agency in the state of Ohio, the August 2025 review identified strengths in our current system. Interviews were conducted in a timely manner. The child was consistently interviewed separately. Assessments were described as comprehensive. Kinship placement requirements and background checks were completed. Those professionals operated within the frameworks of the current law in the state of Ohio, but as legislators, when a tragedy reveals gaps in communication or accountability, it is our responsibility to respond. Kei'Mani's law is about real-time information, clear accountability, and defined communication channels and transparency for the public at large. No system can guarantee perfection, but delayed documentation should never become invisible. Reports should not exist in isolation, and frontline educators should not feel disconnected from the actual outcomes of these cases. This legislation recognizes that when warning signs appear, our system must respond with urgency and coordination. If one child is protected because a liaison follows up, if one report receives a faster review because of automatic notifications, if one pattern is identified because updates are required and visible, then we will have honored Kei'Mani's memory, not with words, but with reform in the state of Ohio. I want to thank my joint sponsor, Representative Brewer, for coming forward. Both of our communities have been affected by this tragedy. Also want to thank Peaches for coming forward and bringing forward suggestions for this meaningful legislation. And I'll turn it over to Representative Brewer at this time.
Thank you, Rep. Williams. Thank you for all being here. As you heard, I'll just reiterate some of the things that you said. You know, everyday educators, caseworkers, law enforcement officers, and judges work to safeguard children from abuse and neglect. But far too often, the system meant to protect them is fragmented. Critical information is being delayed, notifications are missed, responsibilities are unclear, and the gaps between agencies, children can fall through, as you heard from the previous speaker. Kei'Mani law, as we introduce it, attempts to close those gaps. First, this bill requires each public school, as you heard before, to appoint a child protection liaison responsible for managing child abuse or neglect involving students. Schools are often the first place signs of abuse are noticed. This bill creates a clear point of contact, someone accountable for communication, coordination, and follow-through. Child protection liaisons receive comprehensive training on Ohio child protection process, ensuring consistency and competency. Kei'Mani law also strengthens, as you heard before, the Uniform Statewide Automatic Child Welfare Information System, making sure that information is entered promptly and updated. Access to the system will be expanded not only to child protection liaisons, but to juvenile courts, law enforcement agencies, while maintaining strict compliance state and federal privacy laws. While knowledge sharing is a critical aspect of this legislation, it is also important that those trusted with this information are trained and held to the highest standard. That is why the Department of Children and Youth will provide mandatory training to all individuals and entities who access this system. As a state representative, and more importantly, as a trusted adult, as a parent, each in our respective communities, we have responsibility to protect our children. Kei'Mani's law provides guardrails to the child protection process, making sure that the well-being of our children are promoted and safety is prioritized. And as Rep. Williams has stated before, this bill is not just in honor of Kei'Mani, which we are honoring with the name, but it's to protect all the children of Ohio. Me and Rep. Williams are both parents of children, and we have stood with each other bipartisanly with legislation that has dealt with children. And so this is something that we both bring a personal interest in as fathers, as father figures, and as men in the community. So we'll be happy to answer any questions if we have any.
Before we take any questions, I take it very seriously when we introduce legislation that carries someone's name on it. And when members of the family reached out to me, I wanted to make sure that we reached out to all sides of the family to make sure it was okay. Because I don't take that very lightly, putting a young girl's name on a piece of legislation. I don't think there's a single piece of legislation that could have stopped what happened in this situation. This is a true travesty. And when I first heard about this case, it shocked the conscience of me. And I've continued to monitor the case in Lucas County where I just watched the suppression hearing get settled by the court and make sure that that individual stands to justice and is going to answer for the crimes that they are allegedly committed in the community. But anytime we have these gaps in the system, we have to try to find solutions. And one of them is just making our system coordinate. And this is the second time this General Assembly I've had to introduce legislation that's about the abuse, murder, sexual assault of a minor child, and there's a gap in the system. And one of them was VJ's law that I introduced earlier this year about the mandatory reporting requirements. That was part of this bill as we first started drafting it, and we kind of separated into two bills to make sure both children got their portion of their name moving on legislation in the state of Ohio. But at the very least, we should be able to coordinate between departments to make sure that when there's allegations of abuse, neglect, dependency, that the departments aren't operating in isolation. They're not protecting their own budgets. They're not protecting their own staff members to make sure their employees are taken care of, but that we do everything in our power to provide for the safety and security of kids in our community, because these are the ones that we serve to protect.
Yes, sir.
So if there's anything that we can do, if there's any amendments to the bill that the family thinks of, is there any additional steps, we are open to have conversations. We're open to sit down and discuss things that need to be fixed, because this is one of the most egregious cases that I've ever witnessed in my community since I became an elected official. The harm that was brought to this young girl is egregious. And to know that happened at the hands of her own father is shocking to my conscience. And I pray to God at some point that we find a wherewithal in the state of Ohio to renew our death penalty. Because this is one of those cases, if a conviction is actually acquired, I would like to see him put to death. So with that, I ask any questions of people in attendance.
You know, we'll take questions. One thing that we also want to make mention of too is not the effect that it had on the parents, but the community as well.
Yeah.
The community has been very bold in their outcry in this. They've been bold in they want answers. And, you know, not just the gap in when we talk about the gaps that are protecting children, but we also want to protect the parents as well in this too, but it's more about the children. So I just want to bring a knowledge not only to the parents, but also the community that has been affected by this as well. Not just, like I said, Toledo, but it's a ripple down to Cleveland and other places as well.
Any questions?
These new liaisons, are they, are these a new position that each school will have to hire, and how much is this an appropriation for that?
So we do not see it as a new position. We have liaisons. We've seen it with the foster care liaison that just passed out of the Higher Education Committee. We've seen other designations of liaisons. Essentially, we want a point person that we can point to. We know that teachers are mandatory reporters. We want to make sure that there's a person of contact at every single school that we can point to that can say, hey, we've reviewed this case, we can follow up on it. Some of the things that I've learned throughout this process is some of the egregious cases, talking to some of my judges, and I'll give you examples. We'll have cases where there's allegations of abuse or neglect, okay? That will happen outside of the school. It will be raised with Job and Family Child Protective Services. Well, the individual that is the suspect of that investigation will then come and pull a child out of a school. I had that case actually in Ohio when it was a human trafficking case of a juvenile where there was pastors in the city of Toledo that was trafficking a young girl. Well, that girl was pulled out of school in the middle of the investigation when she reported that she was being trafficked. They actually pulled her out of the school. And if you look up those reports in Toledo, it went so far as the wife of one of the suspects actually kidnapped the girl and made her make a voicemail recanting her story. But yet she was pulled out of the school because the school was not aware that that investigation was ongoing. So what we're saying is all of these entities need to be alerted. Whenever there's a allegation of abuse or neglect to a child, the school where the child attends should be alerted. Because whoever is the subject of that investigation should be flagged. So they shouldn't be able to come and get that young kid out of school, whether or not they're in emergency contact or not. That should be a requirement. There should be coordination between the two. Two, there needs to be a better effort of interviewing these young victims. A lot of times, if you just show up at the house where there's an allegation of abuse and you put a young child to the side within the house, there's inherent coercive pressures in the house not to answer questions truthfully. There needs to be an opportunity to interview these individuals with specialists outside of the family setting, outside of the school setting. We need to get better coordination to actually get to the root cause of it. And everything is not just about passing the buck. In this case, yes, there was refers to other community programs such as Ohio Rise. Was there follow-ups, right? My family works in that behavioral health space. There can be a delay between the referral and actual treatment getting there. Where is the gap in between being covered? These are the breakdowns in the system. The coordination is there. We spend a lot of money in the state of Ohio to try to provide for these programs, but it's almost like one department passes the buck to the next one. We're done with our investigation. These liaisons to be, because we know in the state of Ohio, each and every child has to be enrolled in school. They either, very rarely, is homeschooled, but most children are enrolled either in our public schools, our private schools, or our charter schools. There needs to be a liaison at every single one of those schools to be able to coordinate to make sure our kids are taken care of in the state. So that's what we're looking to do. I don't think it creates a new position that we got to allocate new money towards, but there needs to be a designated person, a point of contact, so law enforcement knows who to call, the parent knows who to call. And one of the gaps that we've seen, and this is why I added criminal courts. In my law practice, I've worked with my municipal courts. We will have criminal cases pending in Toledo Municipal Court, in Lucas County Common Pleas Court, of child neglect cases and abuse cases. And there will be a children's services case open at the same time, and the court doesn't know what's going on. So this one, they have due process rights of speedy trial, but the actual child protective services investigation can take longer. So we're trying to settle the criminal portion of a child abuse case without knowing whether or not the allegations have been substantiated by Children's Services. And we don't know the status of that. So that's why we also put it in the bill that upon request, Children's Services needs to provide that information to a criminal court that has jurisdiction. That's one of the coordination pieces that we see missing in the state of Ohio. So great.
Without an appropriation in the bill, that maybe naming a liaison just becomes a box checking exercise for the school, and that is job number 5 or 10 for an employee, and it's not their main focus.
No, I mean, through the committee process, we'll look at if there needs to be an appropriation. We would hope that our schools, being mandatory reporters, are not just checking a box. We understand that we don't also want to have an employee just sitting around in the office all day just in case there's a abuse allegation. We want them to have other responsibilities. But we have guidance counselors in our schools. We have deans. We have other liaisons that are there. We have foster care liaisons under the new legislation. Like, this is reasonable for us to have a point of contact. And this bill, in combination with VJ's law, I think is what brings the real oversight of where, we're going to require you to report. So in this instance, you don't have any reference to law enforcement. You saw there was bruises that were visible. There was allegations of abuse. There was an investigation by Children's Services. There's no mention that law enforcement got involved along the processes. And sometimes the special unit that deals with children, they know how to talk to victims about what's going on and get to the root cause of what's going on. They weren't even referred in this case in the beginning until it was too late, until we're looking for a missing child and we ultimately find that she was murdered in our community. So we're just trying to provide answers and try to fill some of these gaps. I don't think we're ever going to be able to prevent every tragedy in our community. I think we both are Christian men that understand that the devil exists. There's evil in this world, but we can prevent it as much as we can. And if that saves just one life, it's worth us standing here at a press conference and introducing legislation and going through the committee process. Trying to help a grieving family know that they got some justice in this case on top of a criminal conviction.
Anything else?
If I could clarify, and sorry if I just misunderstood, but on the issue of information not being shared with the courts from welfare services, what sort of information isn't making it to the courts, and why is that not happening? Is it just accidental or bureaucratic, or?
Currently, no information is shared with the court. Courts don't have the availability to even request information, and Child Protective Services says during their investigations they're private, so they're non-releasable. So there's no coordination between the two, and the two timelines just don't match up. So as a criminal defense attorney, I mean, if an individual's in custody, he has a very short window that he can be brought to trial. If he's out of custody, it's a little bit longer, but we've had cases that I personally worked on where we continue the case multiple times to try to see if there's a resolution. And I can't even call the caseworker at Children's Services and say, what's the status of the case? Is it close to being concluded? They won't even tell me. They won't tell me whether or not the victim has been interviewed. They won't turn over interview statements to the criminal detectives in the case. There's no coordination between the two departments. They see them as distinct and separate. And I think there has to be better coordination. Anytime there is an allegation, think about this, anytime there's an allegation of an abuse to a child, and that allegation is found to be substantiated, that means a crime occurred in the state of Ohio. Yet those cases are not being referred over to the prosecutor's office unless the parent or legal guardian pushes the issue. So you have cases that are substantiated. I've seen cases where there's allegations of sexual assault on minor children, and they're substantiated by Children's Services, and they were not referred for prosecution. We've seen that in the state of Ohio through my work, and we're saying, look, there's got to be better coordination. Kids, the safety of kids is like non-negotiable for us. So how about our departments actually get together and work in conjunction and make sure that we provide for the safety and security of our kids? I think that's a reasonable request. And again, I just want to thank the family for allowing us to place Kei'Mani's name on this legislation and Peach. Just thank you for bringing forward the idea for part of the legislation. It was meaningful. It was the first time you worked on legislation, so it was a little bit of a learning curve, but we got there. We got there, and it's always, anytime that we can try to bring justice back to our communities, we work hard at it. So we look forward to the committee process. We'll see where it lands, and we will invite the family to come and testify during the committee process to make sure not only your voices are heard, but Kei'Mani's voice actually is heard through the family. So we appreciate your guys' time, and thank you for being here. Thank you so much.